Get started. Good morning. Thanks for taking time out of your busy schedules to attend our business seminars. This is the fifth one that we've had this year, and our goal really is to just educate employers on all the different programs we have at Department of Labor. Today's topic is unemployment insurance, and this is always our most popular topic. I know as employers, you guys have a million questions, and so we knew this would be an important one to have. So we have a lot getting on today. So because of that, we do have the audience muted, but we have the question and answer. It's a little tab at the bottom. You'll see Q&A. We welcome questions in the Q&A, and then they will be answering those throughout the presentation. So again, you are muted as an audience just to keep the background and all the questions to the question and answer tab. And then chat is disabled as well. So if you're used to Zoom meetings where you can chat, and we have that closed down too, in order to be more efficient with all the questions we know we'll get. The last webinar of the year that we're going to have is going to be November 29th, and that'll be on tax compliance. So it goes really well to follow our unemployment insurance. Again, you can reach out to me, or if you have already received your mailings, you're on our list and you're going to get it for next time too. But you can always reach out to me if you did not hear about next month's. As always, like I said, we're really here to help you. You can always visit our website for more information or to contact us. There is an office directory, and you can find your local area of the state, reach out. And if we can't answer it, we will get you to the experts. So it's a great place to start, but please visit our website if you have not. And with that, I am going to turn it over to Wes and Sal, who are from the Unemployment Division and are going to be giving the presentation today. So thank you again for attending.
Thank you, Candy. So good morning, everyone. My name is Sal. I'm a claim specialist supervisor with the Unemployment Division. With me today is Wes.
Good morning.
Wes is an adjudicator. He's probably one of the people that you talk to most often when there's an issue and there's some questions about a former employee and their situation. Wes is the subject matter expert in the investigations and using the rule and law specific to those kinds of investigations. And I'll be leaning on him for a lot of that portion of this presentation. Just to give you a brief overview of what we're going to do today, I'm going to go through a few of the slides here for the presentation, give some of the groundwork, what we do, what we're looking at, some things to know. And then for the most part, I'll be handing it off to Wes, and we're going to try and encourage questions as much as possible closer to the end of the first 6 or 7 slides. We prefer not to go through this entire time frame with just PowerPoint. Really, we want to answer more of your questions as much as possible, but we just want to get a few things out of the way first. So with that, since this is specifically for you, you are paying the tax, you are contributing and being a part of this process more, probably more and more than the last couple of years than some of you might be accustomed to. And I know we've got plenty of questions because we field them all week long, and we're always happy to do so. Let's get started. Before I move into the next slide, there were a couple of notes on the invitation and some of the flyers that you might have received otherwise. Specifically talking about the claim filing process. That's mostly my team's work. If a claimant has some questions about how to file, where to file, all of those things, questions and concerns that pop up along the way, they're more than welcome to contact us by phone, email. We have a click to chat option, which is our instant messaging service available through our website. In our local offices, there's plenty of workforce consultants there that do their best to help them out or direct them to a claim specialist by some means. Now, the next most frequent question that comes with that is the ID.me registration. It is required in order to have an account with the Department of Labor now to get your ID verified, just to prevent ID theft and some of the things that come with that. As you probably heard in the news, we've had to deal with new waves of identity theft these last few years, and we're going to continue that going forward until further notice to prevent as much of that as possible. Now, just briefly on the subject of registering for claimants, it's a bit of a process. We usually recommend between at least a half hour to an hour of, especially if they've never signed up before, getting their profile set up. It's about 23 or so questions. Filing the application is 43 plus questions. And then work history for every employer in the last 2 years they've worked is roughly 17 questions, depending on how they answer. It's a little bit of an investment, but if we can answer as many questions up front as possible, we'll have fewer questions for them through the process, and we can help keep their claim and their potential benefits moving quickly, as quickly as we can anyway. The next topic on that flyer was what happens when a claimant quits or is fired. First and foremost, they have to make sure that that's put on the claim or a weekly certification. But once we have that information, by whatever means we obtain it, again, preferably from the onset, then Wes and his team will be the ones to investigate in detail. If we know that it's valid or we're not sure if we need more information, he's the subject matter expert on those investigations, and he'll go in more in depth into that a little bit later on in the presentation. The last thing on that flyer was also how to protect your account. That's really a big part of this presentation. A lot of the tips that we give and a lot of the references, a lot of the links to the website, different services and different divisions, really at the end of the day, focus on protecting those that are paying into this and keeping it paid appropriately to those who qualify, and only those who qualify as often as possible, because otherwise it just doesn't work and we would be out of a job. Wes and I like our jobs, and we want to make sure that it's done properly. So that's something we'll go into in a little bit more detail here. And the last thing I'm going to open up here is a friendly warning. Wes and I both have a tendency to answer questions or end our answer to questions with "it depends." So much of our work, Wes, I see you shaking your head. Like, yeah, it's so much of our work is dependent on those finer details. Rule and law is explicit in some places, but requires some feedback in others. Wes, would you say that's a fair assessment otherwise?
I do. And again, for this is for unemployment insurance purposes. Sometimes there's things that are outside of unemployment that we tend to not really deal with too much. So, but as you said, Sal, we do say it depends quite frequently.
Thank you. Yeah. So with that, let's go ahead and get started here. First and foremost, the mission statement for the Department of Labor, I think, answers some questions right off the bat, and it's something that we take into consideration frequently. The three big parts of this, connecting job seekers with employment opportunities, that's been paramount, especially these last couple of years and going forward. Big changes from various sources and areas have created a greater demand. We're aware of that, and we're constantly trying to find new ways to work with employers, employment services, and anyone we can to try and direct as much of that traffic towards you and towards the needs that are out there in the community as possible. And of course, supporting workers through their career and life transitions. Nobody wants to be unemployed. Well, by and large, nobody wants to be unemployed, and we want to make sure that those that are actively seeking and just need some kind of assistance through that, as long as they can qualify and as long as they're willing to meet the requirements, we will help them see themselves through that as much as we possibly can within the constraints that we have. And finally, administering the state labor laws. A bunch of us do that. A bunch of different divisions and groups do that. Wes and I have our parts, from when the claimant files to whenever somebody puts in a random question to us by whatever means. But there's also other divisions like the Wage and Hour Department that's explicitly about the labor laws and whether or not something is federally or by state law legal, allowable, if there's some kind of recompensation that's necessary to the employee or what have you. Depending on what your question is, depending on what you're looking for, we have someone that's assigned to doing that or that has an expert view of that subject. And if we don't, I'd be really surprised, but we will put you in the right hands. Next, these are some of the more frequent questions that we receive. First and foremost, what we hear most frequently, I think, is what will this cost me or my business? Again, it depends. That's something called chargeability that we typically look at. Wes's team and my team both, if we see from when someone files that they mentioned your account or your your name as the employer of record at that particular time, we will double check to make sure, were they properly charged? Or is there not enough information to confirm? And then we can go into some of the math about that if you'd like. But really, most of unemployment is like generally like much insurance. You pay into it just in case. And then if a proper claim comes through, then we look at what that entails and whether or not that's going to raise rates or if it's really too insignificant at that particular point. If you only have one person that files a claim every couple of years, or the first time someone files a claim, you're not likely to see any increase to your rates. You're not likely to see a lot of big changes just having to engage in the unemployment insurance process. Versus if your entire staff, because of whatever seasonal reasons, has to get laid off temporarily while the snow hits the ground, you'll see that it's something you'll have to build into the way that you do business. And you can always talk to us about how to see that coming, how to deal with that, what your options are, and we can help you both understand it and potentially work through it to the best of your ability. But as always, that's going to depend on those finer details. Next is really about what kind of employer you're rated as. If you're an experience rated employer, which I assume most of you probably are for attending this, that kind of sets the tone for how we're going to deal with that. But there are also people that don't always immediately understand that they're cost reimbursed or non-covered. We can help explain those in more detail and help you understand what's necessary for those situations. Next up, will this affect my tax rate? Kind of hand in hand with the previous question. Some people like to go straight to the details of that. If you have questions about your tax rate explicitly, then we do recommend that you speak to the tax department or the employer accounts division. Those finer details we don't always have access to, or we can't see enough of to really answer those questions in the kind of detail that is sometimes asked. But we do have a division that will look into that for you. And as long as it's within reason, if there's something odd, we're willing to take a look at that and investigate as needed. But typically, most of those situations and questions, I think that Wes and I have seen over the years, can usually be explained by how many people are filing, your engagement in the process, and whether or not there's an active role being taken there and decisions and determinations being made. But anything outside that scope will put you in the right hands. This is one of the more popular ones, is why was this person allowed benefits? It depends. Finer details, investigation, communication, and we can answer those questions. I don't like to spend too much time on that one because it brings up stories and people by name, and those are private conversations we'd rather handle offline so that we can look as closely as possible and give you the best possible answer. And then lastly, what is IDOL, or Department of Labor, doing to help businesses like mine? The short answer is a lot, a great many things. Back to the mission statement, those 3 items entail a great deal of numerous departments and staff members. But in addition to that, we do year-round testing and process improvements. We're constantly looking for different grants from the feds and trying to fund the efforts, the technology, the staff that's needed to look and clear up things and make things more efficient. We review all tips and complaints, any hint of potential problems or someone trying to deceive or pull up some form of fraud. We do have an entire division dedicated to fraud investigations and making sure that we review everything. There's no circle file is what we hear a lot of times. I sent in something, I asked something, I told somebody, nothing happened. Well, it's not necessarily true. You may or may not, depending on how you contacted the department, get a follow-up. But anything you send to us that there's a suspicion of or concern of something happening that may or may not be illegal or may not be correct, we do investigate, we do verify. It's just in many cases, and we can talk about this in more detail, but in many cases, either the person isn't filing a claim in the first place, or it might have appeared some way, but there's actually justification for something, and we've confirmed and mitigated any potential concerns there. So depending on how you contact us and whether or not you leave contact information, whether or not it's appropriate, we might follow up back on to whoever reported it. We do random IP address inspections. We do sweep and see that people who say that they're in their local area actually are. Not everyone 100% of the time, but we do random checks just to make sure. And that does help us catch some people that may or may not have realized that they were either doing something incorrectly or who were blatantly ignoring some of the requirements to qualify for unemployment. We do work refusal investigations. There's an email address that I'll show later that gives everyone the opportunity to confirm when they have people that show, that applied, but don't either show up or make effort to not get the interview for whatever reasons. If they filed a claim, we can follow up with that. If you've left us information, we can follow up with that. But otherwise, we investigate each one of those to the best of our ability. We do random suspicious activity checks, ID verifications through ID.me. A big pull right now is through the SIDES program. So any of you who are already on SIDES, you might see some updates coming soon in the next 6 months, year and a half or so. SIDES and the employer portal are trying to work to get things like one single sign-on so that you don't have to sign into 2 different websites. But for the time being, until they get that and some other updates about sending more determinations, decisions, more notifications through email and other updates that they're working on, having access to both of those is crucial because it's fast, it's effective, and it really does put you in contact with Department of Labor staff much faster, even than the phone sometimes, depending on how busy we are during that time of year. So the short version is there is a lot. There is plenty going on here. Now, moving along here, we like to make this the probably 50,000 foot overview of what's necessary or what's beneficial to employers like yourselves in terms of preparing for these situations and how to mitigate costs or concerns here. Really, these 4 items are the breakdown as far as Wes and I have looked at this and agree this is a vast overview, but it has so much detail to it when you actually get involved in the process. But preparation in all things. We always, recommend that you make sure that the job posting, the requirements, the necessary tools and training, all of those things are ready and waiting for the person when they're ready to go. The forms, making sure that all the state and federal requirements are met, making sure everything is clearly communicated and the person that's signing on understands. But in addition to that, also preparing for the life of that person's employment with you. Whatever's necessary, whatever changes are needed along the way, you're prepared to enact that and notify them and then document further, which comes into play here next. Documentation in all things. And Wes and his team, they're always looking for specific documents. If you've already been through the process at some point, which I'm sure many of you have, you'll see that specific questions have to be answered. But then on top of that, if you have documentation to prove or disprove another claim, it's the biggest portion of participating, especially in the adjudication process, but also appeals and other processes as well. When did someone start? Did they understand the rules and expectations? Do you have your manual, your expectations written out some way? Was there a witness when there was an incident? Was there corroborating testimony? We're going to ask you a lot of those legally founded questions because preponderance of evidence really rules all things in our world. As Wes says, and you might hear him say it a couple times today, is per unemployment insurance rule and law, employment security law, it's the basis of how we do our jobs. So making a note versus having a signed document will be that small difference that we ask for in order to prove or disprove a situation or confirm whether or not we have enough evidence to make a particular determination. It's immense in our world, though it might be difficult sometimes and add work on your end. In the long run, it'll help out. In addition to that is consistency. What we mean by this is if you have rules and guidelines for your staff, which we know that you all do, you stick to those, especially if there's concern about turnover. If you have a complaint or concern with one employee and then it spreads to another one and to another and to another. Was there a consistency concern? Because that can change the determination from one case to another. If your policy states, if you're late 3 times in a given quarter or month or what have you, by whatever other stipulation there, you could potentially be dismissed from work. But this one person was late 6, 7, 8 times. If you discharge that person, if you fire that person, we're going to ask that why this person was given extra leeway. But this other person, potentially, if there's a close relationship there, they might contrast, compare. But typically it's this person, this time, this reason, this policy. Why was this not consistent? That could work for or against you depending on what documentation you have and what actually occurred based off of testimony as well. So staying consistent as much as possible, sticking to your guns, or drawing a line in the sand. If you're going to move past your typical policy, you have to make sure, or we recommend, I should say, we can't tell you what to do, but we strongly urge you to draw that new line. You were late 3 times. There was a reason for it, and we've allowed that. But from this point going forward, if you're late again in the next 2 months, we're going right back to dismissing you. Documented, signed, dated, witness signed. That's a great way to enforce your policy while still making one particular exception. But even then, details need to go into that investigation for a final determination to take place. So consistency is really important. And finally, communication. Now, we just highly recommend, especially if you have sides, it's an email away. It's quick and easy, but push comes to shove, you can always contact us by a different email. We've got the employer portal that has those encrypted messages, completely safe. It's secured. It's constantly monitored to make sure that nothing's coming in or out unnecessarily. But when in doubt, always feel free to call us. We do have a phone number available that I'll pull up here shortly. If you have a general question, if someone has not been dismissed yet, or you're concerned that there might be a problem looming, or there might be some separations looming for whatever particular reasons, just give us a call. We'll take a look at your situation as best we can, give you some general advice if possible, or put you in the hands of the department that has more information or expertise. Now, that said, Wes and his team are not available for general questions 100% of the time. Once in a great while, we might have somebody available for us for a particular reason. But typically speaking, if you have a question about the adjudication process, my team and a few others can give you a general overview. However, if there is no issue, if there's no active investigation, you're going to have to wait until there either is one, or you're in a particular situation where there's multiple people assigned to a case and multiple people part of a singular case, in which case someone like Wes might be available to you. But by and large, you're going to want to call into the general line to get some base information. Wes, has there ever been any other situation where you've had to speak to someone outside of an active investigation?
Generally, yes, there has been quite a few. And many times when the adjudication team does speak with employers, there's lots of questions that employers are free to ask, of course, and we do provide the information, while we're talking about a specific case. So if an employer does find that you're speaking with an adjudicator, feel free to ask questions of them for anything outside of what's being discussed.
Great, thank you. Right. So yeah, those 4 tips there, big part of what we do, big part of what we hope and expect in order to make the best possible decision and enforce law at the best of our ability. Next up is our main website. I'm going to take a quick look through a few of the tiles here, but this is really a huge hub of information. If you've never been to the main website before, if you've never been to the employer specific page, highly recommend it. So we're going to open this up and take a look here. I'm going to pull this up over to this screen here because it decided to go a different direction. And it still is. There we go. Of course. Okay. Give me just a moment here. I will pull this up. But the main website, there we go. from our main page, if you just hit businesses, more information about businesses, you'll see this come up. I'm going to focus on this center aisle here, but we've got plenty of help with employer recruitment, with the workforce consultants and employment specialists. They actively work in here and provide as much help as they possibly can, help you make job postings, things like that. There are experts for that. I will not speak on their behalf. Apprenticeships. I've been through an apprenticeship presentation a few times. There's some incredible things that work in those programs. You can build your own apprenticeship in many cases. It's something I never knew was possible until I started working here, and it's incredible. If you have any interest in that at all, I highly recommend talking to someone about that. Reporting new hires, which you all do. Hiring veterans, always a great idea, and there's some great programs involved there. We're going to talk about SIDE some more because it is an immense tool for us. And for those of you that like data, I'm a big data buff myself, but if you like looking at what's going on both across the country and in the state, this is a great place to get just base data, base ideas as to what's competitive, what's necessary, what's beneficial for your position and the way that you work. But yeah, a load of information here, but focusing, I'm going to start with e-services here. So this, a lot of our online services, start here, open that up. So first and foremost, if you haven't already, getting your employer portal set up. Again, encrypted messages, work with us directly. If you're not part of this already, we have some concerns, we might have some questions, but at the same time, it's also a great way of communicating with us. I'm stressing the communication here because there's so many of these questions that come up from the employer community that really a phone call or an email could assuage early on. You know, even before something gets out of hand or before you start receiving notices in the mail from us, when a claim is filed, just reaching out would probably save you a lot of stress. And then, of course, there's the SIDE sign up. It's something we're going to harp on a little bit for that communication aspect. And because of the updates that are coming up, both of these things will be working together in tandem, is our goal. But in addition to that, you've got other references, information here to help you. We do have some consolidated references here. So our presentation does touch on some of these 7 ways to lower your unemployment tax rate, but really it's a lot of good practices and how to work with Idaho Works and things like that. So this is by itself a great resource. I'm going to go back to the main list here. This, the unemployment tax help, this is the actual book itself. Let's pull this up. So here is the Employer Handbook to Unemployment Insurance. Now, it's not a long read, but I know many people have not been fans of reading through the whole thing. Many of our staff have for a number of different reasons and training, but it is chock full of information. A lot of the things that we're going to talk about, a lot of the references we make touch back on this handbook and the rule and law that's referenced within. So when in doubt, if not you yourself, and maybe somebody you want to assign to read through and find a reference for something that you might be curious about before you contact us, or maybe after, it's available to you. It's right there, ready to go. And we've got some of our office information as well, if you'd like to reach out to us or come visit for any particular reason. And then the labor laws. This is, if you weren't part of the wage and hour presentation, labor laws is a great place to go for information as well. Pull this up. So they actually do have their own frequently asked questions, their own guides, labor law posters. We do hear every so often there is a scam that goes out there that says for, you know, $50, $150, we'll give you the labor law posters that are required. They're free. They are always free from the Department of Labor. If they're ever not free, please contact us because that probably is a scam. But until further notice. But even then, we've got lots of references to Idaho human rights, agricultural services, state law references, federal laws. We cover a gamut of information on these pages. And we can get you in contact with your local labor law representative. If you've never been here, again, highly recommend it. And of course, again, sides, you'll notice this pops up all over the website, all over our presentation. It is crucial to stay in contact, and it is faster and easier in a lot of cases, especially if you're working out of your email most times. But I can't say enough about this one because it's just the communication breakdown is what causes so much frustration. And we understand that Wes and I both at our staff all have to have these conversations with people when they're at this height of stress and concern until we get to bring it back down and help that understanding take over the emotion. Staying in contact is huge to keeping your stress level down, but also staying active in part of these processes and investigations. So that's as much of the website as I want to cover in detail. Please take a look at it. If you have questions, contact us. Actually, I think there's more contact information at the bottom of this one. I don't want to go too fast. And then, of course, okay, there's the contact us page. This is the last part I wanted to cover. I apologize. Reaching out to us, getting a hold of us, asking questions. Here's the main phone number right here. So 208-947-1055. If you have general questions about unemployment, you can speak directly to one of my staff, myself. Sometimes I man that phone when necessary. But you've got all these other options for contacting us. Again, the employer portal, encrypted messages and sides are also great ways to find out more detail about things that you might see or questions you have. So that's the last part of the website I will cover. And this is just the general breakdown of our expectations for the employer community, just making sure that everyone's ready and able to work, allowed to work. Everything's reported properly. New hires especially, I will stress that new hires being reported helps us catch people that either don't remember or intentionally don't report that they've got a new job while they're still claiming unemployment on another employer. If we catch it, we stop it and we investigate further and we get that cleared up as soon as possible. Because you never know when you're going to be the employer that hires somebody new and they're still claiming, or they're still claiming on you and they're getting hired somewhere else. It's not fun either way, but we will do our best as long as you stay in communication with us. Again, the employer portal and sides, staying in contact. Employment records. Now, depending on who you talk to, federal, state, tax, unemployment, everyone has different requirements for how long they expect you to hold on to employer records or employment records. We typically recommend at least 3 years. Some would say 5 to 10, but you'd want to talk in those specific situations to whoever's involved in that. Can't speak for everybody, but there's good reason to keep it digital, save yourself some space. Never a bad idea. This work refusal email here, this is something we use many times when we have those reports of employees that come in and just bomb interviews unnecessarily for unknown reasons, possibly because they're filing unemployment and they just don't want to get hired. That's always a possibility. We do find those every once in a great while, but you can send us lists as long as there's enough information, name, dates of the interview, if there's a social security number on there, phone numbers, addresses, anything like that. As much information as you can provide to verify those things, we can follow up and investigate. I will just say that typically 1%, just under 1% of the time that we investigate these, they have not filed a claim. So we're not sure if they're filing in another state or if there's just a completely different situation outside of our scope. So when in doubt, feel free to communicate with us, send us the information and we'll take a look at it. If you want follow-up, please make sure that's clear in your email and we'll do our best to get back to you and let you know this is what we found, or this is as much as we can report about what we found before we tell you that there's some things that we're not at liberty legally to share. And of course, as I've been saying, staying in contact. If we send you something, it never hurts to send a phone call and say, is this necessary? If you're not sure, or why do I have to send this? Why do I have to explain this? We're happy to explain in detail if necessary, or at least take a look at what you've received. Now with that, I'm actually going to hand it off to Wes to explain some of the adjudication side of things, unless we have some questions here we want to look at first.
There are a couple of questions that did come in, Sal. I believe I'm going to be addressing the majority of these questions. However, there was a good question. It's regarding the form and the link related to the, and it's the link, it's the work.refusal@labor.idaho.gov. And this is regarding individuals that do not show up for interviews, where an interview is set up and they simply don't show up to the interview. It would be appropriate to utilize that particular link. Hopefully that does answer the question that was posed. And just remember on those, many times I would urge you, if you would like a follow-up, to request a follow-up. You, the employer who's the reporting party on those type of things, may never know what happened with that, with your report, unless you do request a follow-up, and we would definitely contact you and let you know how it went. Just the general sense of what had occurred. And since it is back over to me, I just want to touch on a couple of things. I know there's a couple of questions that did come in, and I'll definitely address these questions that are here. For the purpose of this, the purpose of this information is to assist employers from the need of going into like a retroactive protective posture when they sever a relationship with a former employee and the former employee files for unemployment insurance. This is by giving some helpful pointers as to what will be asked of the employer. In the end, we want to ensure that we are paying benefits when they are allowed and denying benefits when appropriate. And this is directly related to separations of employment. And just as an overview in the scope of what we're talking about, which is unemployment insurance benefits. Unemployment insurance, it's a program which compensates eligible workers for a portion of their wages when they lose their job through no fault of their own. So this is key. The objective of the program is to aid unemployed individuals when they're looking for work by providing a weekly income for a stipulated period of time. The program doesn't allow an experienced labor force to stay in an area during periods of temporary layoffs. It also helps prevent a sharp drop in consumer spending, thus helping avoid another full-scale depression. This is both intent of unemployment and the spirit of unemployment. So when an individual does file for unemployment insurance, an unemployment insurance claim, and that individual has been separated from employment due to quitting a job or being discharged from the job, there must be a determination made by us. If they do file for unemployment insurance, of course, there must be a determination made by us here at the department if the individual is eligible for benefits according to law and rule. As such, that individual goes into the adjudication process. I am an unemployment insurance claims adjudicator. I investigate potentially disqualifying issues on unemployment insurance claims using the methodology of fact-finding interviews with the parties involved in the claim. And the bottom line is to make a formal decision regarding unemployment insurance benefit eligibility. In my job duties, I am not in all adjudicators. We are a non-biased, non-advocatory, objective party. And what we do is we gather and we investigate the facts in order to determine, to issue a decision if the individual is eligible or not. There's two forms of separation. There are some outliers, of course, but the ones that I'll be directly talking about are a discharge from employment, which is when the employer does fire an individual, along with individuals that quit jobs. These are the two separations that are related directly to Idaho Idaho Employment Security Law. And if you would like to write it down, you can reference this yourself. Also, all employers can. This is Idaho Code Section 72, 1366, 5 of the Idaho Unemployment Security Law. And I'll just read it to you real quick. It does provide that claimants shall be eligible for benefits provided that unemployment is not due to the fact that the claimant left employment voluntarily without good cause. So that would be a quit. So again, or that he was discharged for misconduct in connection with his employment. So this is, I'll touch on discharges. The key word is their misconduct. So when it comes to unemployment and a discharge, the employer is the moving party on this type of separation, a discharge. Therefore, the employer does have, for our purposes, the burden to establish employment-related misconduct. That's what could deny the benefit to the claimant. When we talk about misconduct, we here at the department, we define misconduct, what misconduct is according to law. So many times, if you do sever a relationship with an employee, you may have good cause to sever the relationship with the employee. Sometimes the majority of the times, the good cause does rise to the level of misconduct. But what we're attempting to get is information that we try to get facts from the employer that, and those facts may rise to the level of misconduct for our purposes, hence denying the benefit. So a couple of things of what misconduct is, I'll just give you some definitions of that. Apologize for the definitions, but they're pretty important. Some of the elements of misconduct, there's 3 elements of misconduct. One of those is, these are disqualifying elements that could result in a denial of benefits. The first one is a disregard of the employer's interest. So if someone displays a willful, intentional disregard of the employer's business at the work site, a couple of scenarios or a couple of things that could be. A good example would be, I suppose, an individual who were to take the company vehicle to Burning Man. And they also utilize the company credit card to pay their way for this kind of endeavor. Obviously, that would be a willful and intentional disregard of the employer's interest, causing incurring a cost to the employer. And this entire action is without authorization. So that could be a good example, rather extreme, but this is a pretty straightforward type of misconduct event. The next element would be a violation of reasonable rules. So this is where policy comes into play for employers. Policies are pretty important, and what this would be a deliberate violation of the employer's reasonable rules, also known as the policy. The final element is a disregard of standards of behavior. So these are things that, if we make a determination if the employer is objectively reasonable to expect an employee to do a thing or not do a thing at the work site, and if the employee were to have some kind of conduct that was objectively reasonable for the employer to expect them not to do or to do, then in that case, and it resulted in a discharge, that may rise to the level of employment-related misconduct. So in the process for adjudication, what does occur is we hear that what happens is the individual does file for unemployment insurance, does report a separation from employment. At that point, the sides is a tool that employers can utilize to provide information to the department as to, one moment, I apologize. Okay, and the sides is, we are requesting information from the employer. You can provide the information via sides, as we ask the who, what, where, when, and whys on the sides, and you have the opportunity to put the information in that sides, return to the department. If you do provide the sides, just know, or a separation statement back to the department, an adjudicator will always give you a call. Simple as that. And when we do call, we're going to ask specific questions about what had happened, why, and this is related to a discharge, why the discharge occurred. We do tend to focus on the final incident if there was one. Generally, when an individual is discharged from employment, something happens where the employer is prompted to sever the relationship, and it generally happens on a day. For us, that day is pretty important because that is the day that the individual becomes unemployed. If there were an incident that that occurred that resulted in that individual being discharged on that day, This is information that's pretty important to us, and this is basically the number one question that we do ask. We also attempt to get some information. If there was nothing that happened on that last day of work, we try to gather information as to what was going on, or if there was a specific final incident that may have occurred previous to the last day of work that prompted the employer to discharge. These are things like, hey, this is it. This thing happened. We're done. So we will ask about that, and we will go try to get some additional information about any kind of previous incidents that may have occurred. We do ask if there was a policy violation. If so, what was it? And we do request the policy itself. And we also are asking if there were any warnings that were issued to the claimant. And if so, we do request some copies of those and things of that nature. So here's the overall on it. We're obtaining the employer information. At that point, what we do is we do go to the claimant. We provide the information to the claimant. The claimant does have an opportunity to hear the information and respond to it. And generally, we do get claimant information, and sometimes they dispute the information that the employer did provide. At that point, it's rebuttal information from the claimant. And again, there's two parties involved in this separation, both the employer and the claimant. And as the process goes along, the employer does have an opportunity, and we do call the employer and let the employer know what the claimant's response was. The employer does have an opportunity to respond to the claimant information. At that point, remember, the employer does have the burden to establish employment-related misconduct. At that point, it may step the burden up. And the idea would be this, that employer says, this is what had occurred. A claimant says, no, it did not. We do come back to the employer, advise the employer, hey, the claimant's reporting this did not occur. At that point, it may increase the burden to prove the employer's statement. So this is the adjudication process, general overview of it. And as far as documentation goes, and Sal had touched on keeping employee records and things of that nature. So it is always helpful. Just know that the way the process goes, we focus on it can become evidence driven. We do follow the evidence. And the more evidence that the employer may have, meaning documentation, the more documentation the employer has, the better it is for the employer. And I'm speaking, I apologize, I'm speaking in just very general terms on this, because each separation is different, as you folks probably know that. There's many different variables involved in this. However, the standard keeping documentation and employee records of what is going on is very key and very important for employers. The idea would be this, that suppose, just a slight scenario, suppose an individual is late for work and the employer advises the individual, hey, don't be late again. And then the individual is late again. The employer says, hey, don't be late again. And this goes on for many, many weeks or months. And then one day, the employee is late again, and the employer says, hey, that's it, we're done. So if that were the type of scenario, when we do come to the employer, we get the information that's what had occurred. And remember, we do go to the claimant. We may go to the former employee. And when we do go to the former employee may tell us the exact same story. And with that, we will ask, why were you doing this, former employee? And they may say, well, I just didn't know when the axe would come down. I've been doing this all along. The employer kept telling me don't do it again, but I kept doing it again, and nothing ever happened. And then on one day the axe came down. So and that may be exactly what had occurred. We will come back to the employer and we'll ask about warnings. And if the employer had, supposed in this particular scenario, the employer did give a written warning, and it was a final written warning. And on that final written warning, there's an advisement on that. If you, employee, are late again, you will be discharged. And the employer does provide that to the department. Well, this is a piece of evidence that's pretty important because this does establish that the claimants being late again were a willful action because the claimant had been advised. So squarely on the former employee's shoulders, the employer is attempting to preserve the employment relationship, advising the employee what they need to do in order to remain employed. And then the employee just basically disregards it. And then we have a disregard of the employer's interest at that point, and there's a disregard for that employee's own employment.
No way.
So, yes.
I do have a question in there, and
Yes,
this
sir.
comes up frequently. Well, you were talking about the written warnings. Now, one question I receive a lot, or I've heard a lot over the years, is I've given many verbal warnings. Why weren't the verbal warnings counted in that documentation or counted as evidence? You know, I told him a dozen times, but I only wrote him up that last 1 or 2 times before he was dismissed. You know, Mr. Claimant, former employee. What's the difference? What's the validity of a verbal versus a written warning before that separation takes place?
The dispute that could occur with a verbal warning, it comes to mind immediately. Again, with a separation, we have this rebuttal. The individual has an opportunity, the claimant, the employee, former employee has an opportunity to hear that information. That former employee can simply dispute that. Nope, never received verbal warning. The employer may say, yes, that did indeed occur. And with a discharge in unemployment, again, the employer has the burden to establish employment-related misconduct, and that burden is to prove that this, something had occurred. So in that process, if the claimant were to say, this is number one, the claimant may say, no, that never happened. Employer says, yes, it did. So there's that. The other one is it's supporting information. It's not necessarily proof, but even if the claimant were to dispute, no, I never got any warnings, the employer does have a written warning. They do provide it to the department. It's supporting documentation, and it established that that did indeed occur. So I think that is probably the most direct answer that I could give on keeping documentation and keeping warnings. And I would urge employers to be consistent with following their own procedure, be consistent with following through on warnings that are issued. And again, you, the employer, can discharge your employees for any reason that you would like when it comes to unemployment insurance. Again, if the individual does file for unemployment insurance, it's the employment-related misconduct according to law and rule that could deny the benefit. So keeping that in mind, like I said, the documentation and records are very, very important when it comes to a separation, for sure. And with that, there's some questions here. I don't know, Sal, can you look at these questions? If you would like to ask those, or I could ask these questions that did come in and address these.
Sure, I'll start from the top here, and then
Okay.
we'll see where they fall going forward. So first one I see here, see, all right, I'm going to summarize this one a little bit because there's some detail here, but essentially questions about seasonal employment and staff. There's a team of full-time employees who worked for us for years. They get laid off during the winter months, it sounds like, so probably working outside or weather-dependent work of some kind. Is there a way to make this process easier for them? And then there's an add-on there about them possibly working a few hours per week, and how that affects their unemployment. So we will, as long as they're filing claims, the claim specialist side of things, we will be available to them. They can go into the local offices and possibly talk to what's called a UI navigator, if that office has one available, which is a person that works with my team and with my division, who can talk to them directly and help them, coach them through the filing process. It's a single person that does get inundated depending on how busy things get. So there might be a bit of a wait there. They might want to call in, but there are multiple options available to reaching out for assistance, getting some coaching through how to file, where to go, what's necessary. If they need anything additional to that, would probably lean back on going to a navigator, scheduling an appointment. But for the most part, as long as they're willing to listen, willing to get coached, we will find some way to reach out to them or to be available to them, by phone, by chat, by email, by office visits, find a way to help them through that filing process. And if things come up along the way, like some work, as long as they're reporting work in the week that they actually did do the work itself. So one of the things you might hear from the claim specialist side of things is, when did you do the work and how much do you get paid per hour? Those are usually the two questions we ask a lot regarding weekly certifications and weekly work, even through a layoff. So if they're normally a full-time employee, which the Department of Labor considers 40 hours per week full-time, and they get laid off, whatever, if whatever they're doing outside, normally if it's construction, if it's landscaping, and they have to switch gears from landscaping, for example, to moving snow, getting clearing driveways, clearing sidewalks and things like that, which a lot of people do to make sure there's still some kind of income coming through, then you can work them. Of course, we can't tell you what to do. However, they need to, as long as they're filing a claim, they need to report the work and how much they get paid per hour on that weekly certification, not when they get paid, because we're looking at the actual week that they did the work and what their earnings should be, their gross total earnings should be for that week. And that might qualify or disqualify still, depending on how much it is. It might lower how much that weekly payment is from the Department of Labor. Again, those details are really crucial. Those numbers are essential to making that calculation work properly. So that's something either you might want to call in on behalf of your employees, depending on how that works out best for all of you, or they need to reach out to us. We just need to put the right information in the right hands to make sure that that's going to work out to the best of their ability or in their favor as often as possible, as long as they qualify.
So the next question, if I were to discharge someone that has been with the company for a couple of weeks, what type of documentation do I need? So if the individual does file for unemployment insurance and it is a discharge, what I would urge you to have on hand is just the facts. That's what we will request of the employer, is just the facts. And remember, with those facts that we obtain from the employer, we do go to the claimant. The claimant has the opportunity to hear the information, respond to it. So the facts are important. And again, with that information, we will come back to the employer, let the employer know what the claimant had to say. And if there's any kind of rebuttal information, we will go from there and request additional if necessary. The next one, are there benefits that a person could receive if they showed that they worked at a company for one day? If we had an increased number of employees starting working one day and leaving without any notice, would there be a benefit associated with that person being able to show that they had actually been employed, even though it was brief? Now, I didn't quite touch on this, but this is there's two separations, a discharge and a quit. I didn't touch on the quits because this is more employer focused. However, the employer is an interested party, of course, if somebody does quit their job. So with a quit and unemployment, what we do is we do go to the claimant. The claimant does have the burden to establish good cause for quitting the job related to the job itself. So what we do in that particular circumstances is we go to the employer first, or I'm sorry, go to the claimant first, the former employee, because they are the moving party. And we do ask them specific questions. With the information that we do obtain from the claimant, we will go to the employer, review that with the employer. The employer does have the opportunity to hear the information, respond to it. Also, it's basically the same process, but it's claimant driven because they're the moving party. So with this particular question right here, it appears to be a quit. And the question is really, would there be any benefit associated with the person being able to show that they had actually been employed, even though it was brief? The question kind of crosses over into a couple of different things, but if this individual was working for an employer even for one day and it was a quit and the individual filed for unemployment insurance, we would again go to the claimant to get the information. And then after that, we would go to the employer. If there was, That's the best I could do with that particular question.
Just depends.
Yeah, it does depend. And remember, for unemployment insurance purposes, we would go through that if somebody did file an unemployment insurance claim to
Right.
determine eligibility. The next one was regarding the work refusal link that we did provide. So the next one, how are you informed when people are interviewing? Is it just the person telling you that they had an interview? There's a lot of ghosting, yes. Again, Sal, you could touch on that because you did touch on the work refusal
Sure.
link. Sure.
Yeah, and that those phone calls, those emails, using the work refusal email, especially, that's a great place to let us know. Again, when we do those investigations, when we do follow up both with the claimant and potentially follow up with you if you leave the contact information, it's an odd trend. We do see sometimes. I actually received an email. I worked with an employer at one point for 2 or 3 weeks straight because this particular representative had 50, something like 50, 40 or 50 people list of people that were applying, and they either not showing up or coming to the interview and absolutely making a travesty of it, clearly citing her suspicions. So she gave me all the information she had, which was, I mean, I like spreadsheets, but that was an interesting one. So I had to go name by name, social by social, double checking who had claims, who didn't. And in that case, very much the same thing as I was saying before. There was probably 2 people that actually had an unemployment claim with the state of Idaho. Now, I can't see if they have claims in other states, if there's potential fraud there, or if they have benefits there that, from a previous employer and recently moved. Those things I can't see. However, I can at least follow up and get that information. But if we never hear about it from the claimant or from the employer, no, there's very little that would give us that red flag to say this needs to be looked at. So that's why we stress communication so much. We do make a lot of requests of the claimant. We do have to take a lot of their information to a certain extent on face value, but if there is corroborating evidence or if there is a way to double check, that's within our power sometimes, but not always. So if we get a second interested party, like the employer that's receiving these applications or has these interviews scheduled and no one shows up, or, like I said, it's more of a scene than an actual interview, hearing back helps us make that possible, helps us make the investigation and the verification possible. Because the ones that we do find, like I said, we will potentially stop benefits right there and then, pend an issue and say, Mr. Claimant, this person has notified us that something happened. What's your side of it? And if they say, I don't know who that is, I don't know what's going on, I don't know what you're talking about, like, okay, well, they provided me dates and times and information. There's a form, there's an application, your name, your signature. What can you provide to refute this? That's usually where the phone goes dead. And that's a conversation we have to end up having with adjudication. Well, got some issues for you. Need that investigation to go through? Have at you. But in other cases, if there's just nothing there, we just have to say, we apologize, we've investigated, but there's nothing to show that this is happening in state or that anything's happening at all. So if you continue telling us and letting us know, we'll continue checking. As I said, that was like a 2 or 3 week assignment, and eventually we got some leads and we helped her out. But if you keep it up, we will continue doing so. We'll continue working on it.
Yeah, and so what you're saying, it's only important if the report comes into us and that individual is filing for unemployment insurance. Is that correct?
Right, because we have limitations on our scope here.
Meaning, if that individual does do this ghosting type thing and they're not filing for unemployment insurance, then we have no avenue of attack whatsoever.
No recourse at that point, unless the employer wants to contact another entity of some kind to see if there's additional help. But I don't know of any resources off the top of my head there either. So, but still, it opens up the dialogue, and we're happy to figure it out if at all possible.
And moving along, next question is, what is the maximum number of hours an employee can work to still receive unemployment insurance benefits when work is available at reduced hours? That is a very large question. It does involve a formula that we have here at the department. And it's individuals that are working for an employer and working less than 40 hours a week and are earning a certain amount of money. So I can't give you an exact sum on that because it's dependent on what their weekly benefit amount is. But I can tell you that individuals are eligible to file for unemployment insurance if they're working less than full time. If they are working full time, then obviously they're not unemployed for unemployment insurance purposes. They're fully employed. But for those individuals that are working, say, part-time, they can file their weekly unemployment insurance claims. All the personal eligibility requirements are intact. They have to meet all the personal eligibility requirements, and they are requested to report the work earnings and the work that they had during any given week that they do file for.
Correct.
Hopefully that answers that question. If it goes into, again, just to put that statement out there, there's a math equation that's used, and it's on an individual basis for the amount that they can earn.
I would like to add, and this is Wes and I really like our jobs, so we're not joyful at anyone's unfortunate circumstances, but we like the challenge. We like being of service. We like helping and educating as much as possible, which is why we volunteer for events like these. But when I get those phone calls from claimants or employers, and sometimes both, which is a very interesting phone call when I have everybody on the line at the same time. Math time. I mean, there's several different places where we're looking at formula, we're looking at wages, we're looking at hours, and we're doing some quick math. I'm always happy to help people with the quick math. My staff is always happy to help people with the quick math, but depending on what you're paying them, depending on how many hours, depending on the benefit, depending on any number of different things, it's a quick math check, and we can do it over the phone immediately if you give us a call and try to figure out what that is. Keeping in mind that if there's some limitations to that too, if there is a semblance of cooperation that's going on between multiple parties, that's an iffy, that's a slippery slope situation. Cooperation turns into an investigation if certain red flags are peaked there. So keeping in mind, best of your ability, if it's a general question, just give us a call. But if you're actively working with someone to somehow garner both and still balance, if certain criteria are met that we can talk about in more detail in those situations, we might ask more questions before we go into what that math would be, what the setup should or could possibly be. So there's so much more that goes into that, and I don't want to spend too much time on it. I apologize, but just making sure if you're trying to help people out, absolutely understand, give us a call. We'll do our best. Thanks.
Next question.
Yeah,
what about employees who know that their employment is a seasonal thing and they still file unemployment after their seasonal period ends? So my adjudicator mind goes in many different directions on this particular question, but what I can let you know, and I think the question may be, well, it could be that someone is a seasonal employee, they're laid off, the season ends, and they either come back to work and continue to file while they're working. So if that were the case, then of course, this is something that the department would deal with. We would find out that they are working for the employer. And this would be a conversation with the claimant. Most likely the employer would be the interested party. The interested employer in this particular case, the employer would be aware that this had occurred. So this is one thing that I can think of. The other was that the individual doesn't come back to work. They are given a definite date to return to work. They don't come back to work. If that were the case, then us adjudicators do go to the claims and we obtain information from the claimant as to what had happened. And many times these type of scenarios, if it's that type, it turns into a personal eligibility issue that we do hash out with the claimant. Hopefully that answers the question. If not, we could take, maybe some clarifying things on this through the chat. The next question, if the verbal warning is noted under prior action taken on a written warning, when the employee signs the disciplinary action form, will that solidify the verbal warning did occur since they did not contest it on the form?
Okay, I do have a mention on this one,
Yeah.
only because so when we used to do more of these presentations live, we usually had a wage and hour and staff member with us who could field some questions like this. This kind of situation about what's on the actual form, what you can and can't put, what does and does not, qualify for certain forms of validity. This might be something you might want to take directly to your local wage and hour staff member, because they can look at your forms. We can't tell you what to do. We can't tell you what to say. However, if you send them or if you ask them for their time to send in your forms, your write-ups and things like that, your policies and procedures, sometimes they'll be able to give you some tips or give you a heads up as this doesn't meet state qualifications. This doesn't meet federal qualifications that are necessary to make that valid in certain situations, but you might want to do X, Y, Z, and they can try to help you work that out. On the other side of that, my concern, and Wes, I think I take this back to you in a moment here, but what I've seen in the past is that if you have like a form that has multiple options printed on it, this is a verbal written final warning, and you have to circle one or check a box and then detail what's going on with date and sign at the bottom somewhere or somewhere on the page. Sometimes that'll work because it's very clearly delineated, like this is a verbal warning, a documentation of a verbal warning, in which case, if your policy says 5 verbal warnings equals 1 written warning, or 5 verbal warnings leads to written warnings, from then written warnings become 3 to 5, whatever it happens to be, whatever your policy happens to be, before dismissal or suspension or something like that. As long as you have the whole path laid out and each of those documents is clearly labeled so that we know whether or not it's met the policy, that can help in those situations. But just writing on there prior action taken, I've never seen that work too well. Wes, what about you?
Well, I can tell you the answer to the question. I understand the question. The question is yes. The answer is yes.
Okay.
It is. So if there's a verbal warning and it's and there's a written warning, the idea with I'm thinking the idea is this, that there's a written warning that is given, and on the written warning it indicates previously on this particular date you had done the same thing. And then now remember, on written warnings generally there's a statement that says, I, the employee, acknowledge I'm receiving the warning. Right? They're not admitting to whatever infraction is being alleged to have occurred. They're just saying, yeah, I agree, I concur, basically on the written warning. But I would tell you that if a written warning went that way and it said, here, on this date you did this, on this date you did this, and now today you did this, and don't do it again or you could lose your job, and the individual signs on it, date and time, date stamp on there, right? Then the answer to this is yes. It would support employer's position, right? And again, we're looking for supporting documentation, things that can support your position, you, the employer, and this would indeed support your position. Yes. So moving on, the next question, what would be the point on appeal? I believe it's what would be the point of an appeal then? I'm just going to read it directly. What would be the point an appeal then has to be appealed again through the Industrial Commission? Is the Industrial Commission part of DOL? So first part of the question, I can answer that. Sal, you probably grab the second part, but the first part of the question, well, the appeal, and I don't really want to touch too much on the appeal. However, when a decision is made, the individuals are notified of the decision via mail. So on that letter, it's the decision letter. Both parties do get a copy of that. There's our appeal right. So if either party happens to disagree with that decision, either party can appeal that decision. The process for the appeal is listed at the bottom of the document. This is the part of the appeal. And anybody has if anybody any party disagrees with the decision, they're in due process. They do have the right to appeal that decision. And I'll leave it at that. And then as far as the Industrial Commission, you could touch on that, Sal, if you'd like.
Sure. Yeah, they're not Department of Labor. It's a separate entity, but they're the other check. So the appeals department is one of the checks and balances in-house for the Department of Labor. We don't cooperate. We don't work together. Wes's department or mine, most in fact, because they're the ones that verify whether or not the determinations or decisions that were made meet rule and law. And if they, if somebody, files that appeal because they disagree with it, if they think that the burden of proof has been met or something was done incorrectly, they can overturn that decision. If one of those interested parties takes it up to that next level, the Industrial Commission then reviews to see if the appeal itself, the hearing itself, was conducted properly, and if all requirements were met, then they will take that and they will affirm or change that or send it back for remand or something like that. They're another check and balance to that process. The next step after that is, to my understanding, unless anything's changed recently, is going to the Supreme Court. So if you have questions about a specific appeal, you might want to speak to the appeals department. Otherwise, if you have general questions, you can contact that employer line again and speak to one of us. We can take a look at the case and see what the notes are in detail a little bit more. But particular cases like that, that's definitely going to be an offline conversation, no matter what, just to clarify what happened and what interested party is concerned about what piece.
So the next question, what is the best way to assist an employee when we have location temporarily closed due to renovation and they are temporarily laid off? Well, you, the employer, and I think it's within the scope of unemployment insurance. This question is within the scope of unemployment insurance. The individual can file an unemployment insurance claim. And you, the employer, may do whatever you can do, or what, but the fact is the claimant's eligible for unemployment can file an unemployment insurance claim. And that is the answer to that particular question. Next question is going to be for you, Sal. Is there a possibility to bring a UI navigator to our business to train on unemployment claims process for our school year employees who are laid off attached for 12 weeks in the summer?
That is possible. So let me open up my OneNote here so I can make a note of this and see if I can get some additional contact there. But yeah, if you send in either from any of the means, the employer portal or a phone call, if you want to send a request to us for what we frequently call a rapid response, or sometimes just some assistance in general in preparation for a situation, we'll do our best. It's not a guarantee, depending on the time of year, staffing, and whatever other details that might be part of that situation. But by and large, we do our best to try to assign somebody. It may or may not be a navigator necessarily, but it will be at least one or two members of the staff here at the Department of Labor. We can set up an event, see what kind of audience we have, see what requirements are needed, and we can come out, visit, talk you through, go through a PowerPoint, show you the website, and then hang out for a while and walk people through, kind of coach them through signing up or filing. But there's a lot more detail needed there, depending on what's actually necessary and what level, so we can prepare to be most accurate to your need. But yeah, please feel free, give us a call. I'm going to take down that name and contact and see if I have enough contact information to get a hold of you directly. But
and I believe it's an add-on on this one. I think it's the same one. I deleted off that first question, but or possibly a training video that we could use. I think it's related to the same thing. Department of Labor does have a YouTube channel, and we do have many of our more recent additions to trainings, tips and tricks and not tricks, but tips on how to work through filing, what's required, things to look for, documents to have ready, things like that. So you might want to take a look at that and see if that covers some of the questions you have first. And then if you still want that hands-on approach, then we can talk about that offline. What is the maximum benefit amount?
Currently, last I checked, it was 532. We've recently
Yeah.
got some updates.
Yep, I believe you are correct. I don't deal with that every day, but I believe that is correct.
There've been some recent updates for the coming years, so I
So,
just want to make sure I'm not crossing over any of my entire inbox in my head kind of popping up. But yes, it should be at or near $532 per week. And that'll change. That can potentially change. And that's another math problem that we get to look at. Technically, our boss's boss's boss gets to look at and then updates us and updates the website as to when, based off of employment rate, unemployment trends, they will change that based off of the formula that they use, and then the number of weeks, the maximum number of weeks, and the maximum benefit amount will change. But currently, that's where we're at, 532.
yeah, and with that response, just know that we are looking at the weekly benefit amount.
Yes,
it doesn't specify exactly what maximum benefit, but that would be it. The next question is a little off topic, but I have a hard time finding the right place and logging in to report new hires. Is there a good contact to assist with that?
Yeah, I would absolutely recommend going to that primary contact phone number first and foremost. But otherwise, we can either walk you through the website itself, or we can put you in contact with the employer accounts division if there's something more in addition to just where to file the new hires. But yeah, everything can start with just a phone call, and then we can redirect from there if needed. Absolutely.
Could you send an employee an email to summarize a verbal warning and save in their file to document the verbal? Of course you could. Now, if you were to do something of this nature, this would be something if the individual did file for unemployment insurance and we requested some additional supporting documentation, this is something that you could provide to the department. So absolutely, you can. I believe that answers the question.
Yeah. I mean, there might be some more details that you get to look at in
Sure,
that case. But
sure.
yeah,
It would be, yeah, again, the idea is supporting documentation. If the employer says something happened and they did document that it did indeed occur, it would be something important that the employer would like to, or it can provide to the department for consideration. Again, we follow the evidence. So that would be a portion of evidence.
All right, next we have, if an elected official is not re-elected by the local citizens, would that person qualify for UI benefits after the end of employment when the newly elected individual is sworn in? That one, I'm going to want to look at in a little bit more detail before I give any kind of answer to that. That's
likewise.
Yeah. Elected officials is something specific that we do look at and ask about on the claim itself. So details to this one, in order to give you the best possible answer, would be appreciated offline. Please feel free to give us a call.
This one is it's very detailed dependent. I can tell you that it's very detailed dependent. We need additional information in order to answer that question correctly.
Sorry about that, but that is, like we said, it's a big part of our world. All right,
when someone files for reduced hours and then those hours increase, how can we see or report if they are still filing?
I mean, I think the simplest way, again, I feel like I don't intend to be repetitive, but really give us a call. If you're the interested party, you can verify that while we're on the phone real quick. Give us the person's social or the name or something that we can pull up. If they're filing a claim and you've increased their hours, if we haven't seen the increase, and again, depending on the details they're in, they might potentially still qualify for partial benefits, or they might not be reporting it, in which case we need to verify that, potentially stop benefits and investigate further. So when in doubt, just reach out and we'll take a look at it. But in some cases, if the increase is not enough in the first place to change anything on their claim, we might just have to tell you that, unfortunately, based off of what you've told us and what they've reported, there's no change to benefits. They still technically qualify. Now, if you bring them back up to 30, 35, 40 hours, that'll change things greatly. But we can talk about that in more detail once you reach out to us.
If an individual is filing for unemployment insurance and working for an employer, we here at the department do request information from employers on weekly claim earnings. The employer has the opportunity to fill that form out, return it to the department. If we do notice a discrepancy in the earning amount reported, we do follow our investigatory process. I believe that answers the question. Because I think you may be asking, how can you, the employer, see it or know about it? If this were a thing that we were to go through or investigate, you, the employer, would be advised of it, and really, you'd be the reporting party on this, giving us the information. We here at the department do handle these particular type of cases, and you, the employer, will be aware of it. Yeah.
Absolutely.
Yeah.
And then next we have, not sure if I missed this, but what do you do if the employee declines to sign the verbal or written warning form? I've actually been party to this in previous work. My standard operating procedure for my previous industry was whenever, regardless if it's a verbal or written or suspension notice, any of those, any disciplinary action has to have 3 parties minimum, which is the person issuing this notification, the person receiving it, and a witness. So in this case, I would highly suggest having that third party available to sign off and witness and testify, even putting down a little note there. This person refused to sign. I bore witness this time and date, signature. At least then that you offered it, you notified them of the concern about what was necessary about the disciplinary action policy, whatever it happens to be that you're adding to that form, and you've got it documented, corroborated by a third party. And if that person wants to dispute the validity of that comes later. But at the very least, you've got a document that shows you made the effort and somebody confirmed they refused to participate, but they are aware. Wes, you've probably dealt with more of these more recently.
Yeah, so an individual can, decline to sign anything, of course. If the employer is issuing a written warning to an individual and they refuse to sign it, generally a written warning, again, I kind of cover this, written warning has a statement on here. I'm not admitting to anything, but I'm acknowledging I received the warning. And that's what it is. It's an acknowledgement that they did receive the warning. If they refuse to sign that they are, they're refusing to acknowledge that they received that, they generally will argue, I'm refusing to sign this because this did not occur. So, I mean, if that's the kind of situation that's going on, it really doesn't matter, because really that signing is them acknowledging they received the warning. If it became a dispute between the claimant and the employer on the warning, again, we're going to follow through on our fact-finding interview stuff, and we will, get the information from either party. But the point is, if you have documentation as a documented warning, and there's no signature on there, we're going to request that information from you, and whatever may occur from that point forward in the investigation will occur. If there's a matter of dispute, of course, both parties can provide their position on that dispute. Yeah.
Nice. Now, I do apologize. We've got one question left, and this will be probably the last one we answer. We are at time. We don't want to hold anyone up unnecessarily, but this will be the final question, and then we're going to have to break. But please feel free to contact us. We're available Monday through Friday. My team's available Monday through Friday, 8 a.m. to 5 p.m. Mountain Time, except for weekends and bank holidays. But anything else after that, if you have an investigation, you might get lucky enough to have Wes and get to talk to him one-on-one. But so we can get that last one figured out before we leave anyone hanging here. If our staff are receiving UI in the winter landscaping company, but the staff is required to work snow removal when it snows, and they do not show up for work when it snows, is that considered a refusal of work, since we are offering the staff hours to work and need them to work?
Could be.
Yeah.
Could be. If we have this situation, that indeed the employer can provide this, can report this to the department, and we will definitely go through it. Again, there's 2 parties involved in this, both the employer and the claimant. We would go through this matter, investigate it thoroughly, and make a determination if benefits should be paid with this type of scenario. Yeah.
All right. Thank you all so much. We really appreciate the time and we hope this was helpful to you all. Again, please feel free to get in contact with us and get some general questions answered or reach out to whatever division or department is necessary in your particular situation. I do have one name that I will be following up on as best I can. Candy, is there anything else that we need for the day?
Yeah, no, thank you so much, Wes and Sal, for navigating through what can be sometimes difficult on unemployment insurance. That's why it's an important topic to bring to employers. Thanks for spending your time with us. Employers, thanks for joining. We will have our last webinar of the year, November 29th. It'll be tax compliance, so follows up nicely to unemployment insurance. And within a couple days, you will receive an email from the Department of Labor, and we will have a link to the recording today out on our YouTube channel. So look for that. And again, our website has a ton of information, a lot of frequently asked questions and answers out there for you. So please use that as a resource as well. Thank you.
Thanks, everyone.
Thanks.